I reflected that Cleveland passed an assault weapons ban in 1991, a ban that stood for 19 years. That is, until a new Attorney General, a Democrat, took office. It has been reported that the new AG, quote, defended, unquote, a state law which superseded local laws. The truth is, neither he nor any of the attorneys general who preceded him was required by law to enter any case, since the Ohio Attorney General's office is constitutionally independent. This particular Attorney General elected to take up the case. Why? He did so at the prompting of Ohio's gun organizations and the NRA. In order to ingratiate himself with the gun lobby, he initiated court action, which led to the repeal of Cleveland's assault weapons ban and blocked every other city in Ohio from taking similar action. To put an exclamation point on his rationale for leading the way to overturn local assault bans, he later called the court's decision, quote, a victory for gun owners, unquote. Now, I dug further into the Democratic Attorney General's relationship with the NRA and discovered that he and the Texas Attorney General were leaders in a case popularly known as the NRA versus Chicago, which had the practical effect of undermining every single public safety ordinance relating to guns in every city in America. Cleveland, Columbus, and a number of Ohio cities were on one side trying to protect the streets of our cities, and Richard Cordray and the NRA were on the other. On March 1st, 2010, the Plain Dealer wrote that the Democratic Attorney General's support of the NRA case, quote, could ultimately make it tougher for cities to pass and enforce highly restrictive local gun control laws. If the High Court agrees with the positions taken separately by Cordray and the National Rifle Association, it could handcuff the ability of Cleveland, Columbus, and cities nationwide to respond to gun-related violence, the city's attorneys contended in a legal filing. As a city, this is a quote, as a city confronted with safety issues day in and day out, do we have the ability to ultimately do something about it? Asked Cleveland's law director. Now, home rule is a fundamental principle of self-determination, which is accorded every city under the Ohio Constitution. But the then Attorney General, a Democrat, single-handedly dismissed home rule as a right and made it subordinate to the gun lobby. Here is the political and moral blind alley he led local communities and states into. They are now strictly limited to what they can do to regulate gun violence. Those who advocated for Ohio cities said state judgment should not be replaced by a federal constitutional standard, that states should be allowed to continue to experiment with solutions to gun-related violence in their communities. Mr. Cordray, unfortunately, stood with the NRA against the states, specifically against the cities of Cleveland and Columbus. For his efforts in the Ohio Supreme Court and the U.S. Supreme Court on behalf of the gun lobby, he earned an A from the NRA. He was the first Democrat on the case, the first Democratic state official in the nation on this case to work with them. Quote, every single official act Richard Cordray has ever taken has been consistent with a vibrant support of your Second Amendment rights, unquote, said the Buckeye Firearms Foundation in its endorsement. One unpublicized official act was a very unusual intervention with the Capitol Square Commission. As the Commission's attorney, the Attorney General directed it to permit an armed group to have a rally on the State House grounds, even taking the extraordinary step of assuming personal responsibility for waiving an insurance requirement in the event of an incident. Now, given this mendacity, one could only imagine the direction Ohio could be taken. As Attorney General, Mr. Cordray clearly made his office an extension of the NRA, even bragging to gun groups that he seized the, quote, opportunity, unquote, to use the power of his office to represent their interests on assault weapons and all gun issues. After Parkland raised a public outcry over assault weapons, Sadly, Mr. Cordray falsely claimed at a candidates forum in Union County just 2 days ago that state law forced him to take up the case against Cleveland, when, if he had any pangs of conscience, he could have easily hired special counsel to defend the legislature's actions, something the AG's office, under his control, spent millions on every year. Instead, he volunteered to take up the case of the NRA.